Hi, Attorney Carlos Colombo with you again, and today we have a very special guest, Mandy Nease, one of our attorneys. Mandy, welcome again to our channel.
Thank you for having me.
Oh,
Good to
no.
see you.
It's great. And today we're going to have a very relaxed conversation about an interesting topic, the O-1A under the Trump administration, and we're going to have Mandy as a former USCIS officer. She's going to give us her perspective of where we are today. What is it, about 60 days into the Trump administration, what we are seeing with O-1A cases. Are there any changes? Are there any issues we should keep an eye on? And what do we expect for the rest of 2025 with O-1As under Trump? So Mandy, welcome. First of all, if you want to sort of tell the audience a little bit about yourself, maybe they haven't seen you, it's like a little bit of your background. I think everybody finds your background fairly interesting for immigration, and we are blessed at Colombo and Hurd to have your background, your wisdom. So maybe you can share that with some of our audience.
Oh, thank you. I'd be happy to. My name is Mandy Nease. I'm an attorney here with Colombo Hurd. Prior to re-entering private practice, I served as an adjudicator at the Nebraska Service Center for 13 years. And my work there focused on I-140s, including national interest waivers, Schedule A's, and labor certificate cases. And prior to that, I did 45 green card applications, TPS, I-130s, asylum 485s, and I think there's a few other things in there that I can't remember, but a variety of things over the years as a 485 officer as that work ebbed and flowed.
Well, and that gives you, a very broad perspective. Obviously, not every officer at USCIS gets to do that many cases, or that many types of cases necessarily. And you worked on some of the most challenging types of cases, which are for adjudicators a lot of the times the EB cases, right? EB1, EB2s, EB3s with labor certs. On the O1 has become, in the last few years, fairly interesting because they have made it a little bit more flexible in some regards. Perhaps intentionally, perhaps unintentionally, we don't really know that, right? Because of some of the backlogs that we're seeing in the EB categories, EB1, EB2, and EB3, perhaps USCIS sees this as an option, a temporary option, while you're waiting for a green card for certain folks. So I think the first topic I would like to talk about is a little bit of how the past administration Biden had sort of opened up a little bit of those applicants towards accepting EB1A applicants that maybe before were not your traditional EB1A applicants, and the sponsorships, because a lot of people don't realize EB1 O1As are a sponsored visa. You cannot self-sponsor with an O1A, but who can qualify as that sponsor has been interpreted to mean various types of entities and folks. So can you talk a little bit about that?
Sure. So one thing that we've seen under the Biden administration were the STEM adjudication guidelines, and then also the allowance of a company that an applicant is a majority shareholder in being able to petition for that applicant. So those are two subtle but important changes for entrepreneurs, and especially for STEM entrepreneurs, because they have a lot of opportunity to come to the U.S., work on their own entity, and then have that entity be able to sponsor them for an O1A. And if they've been in a critical role, which most of them are, if you're a founder, you're going to be in a critical role. And the other piece of that is when we look at high remuneration, we can look at the value of the company and use that in the high remuneration analysis. The other thing that they have allowed is for funding, like venture capital funding, if someone invests in your business, to be counted in the qualification analysis, We usually see that incorporated into the petitions either as an award or as part of the high remuneration analysis, or we have this category that USCIS allows for entrepreneurs whose accomplishments don't fit into the traditional criteria to be counted as evidence of their high achievement. So if we have awards, we can put them into a couple of different places in the application to demonstrate high achievement as recognized through that investment. So there's some really nice things there that have happened over the years to make it a little bit more accessible to entrepreneurs.
Right. And we're not going to talk today, we're not going to get into all the details regarding the requirements of an O-1. That's not the purpose of the video today. But here's a link right here that we'll put on the screen that you can click on and you can learn. It's a video about the actual requirements for an O-1A and what criteria USCIS will look for. Some of the ones you mentioned, Mandy, these were certain requirements that it's not a new law per se because Congress hasn't changed immigration law in over 30 years, but it's the way that the different administrations may interpret existing laws for the O-1A. So if we go back under Biden, they seem to open up some of these opportunities for O-1As. Have we seen in the first few months of the Trump administration any changes that we can talk about?
I have not seen changes under the Trump administration when it comes to the O-1 policies or procedures. One thing that I think would be useful for our audience to understand is that something that can impact the processing of these applications is federal staffing. So people may have heard about Trump's efforts to reduce staff across the federal workforce. DHS, which is the directorate that USCIS is under, has pushed back on the Trump administration's efforts to reduce their staff and has said that their staff is critical. And so far that has worked. So far we haven't seen layoffs at USCIS. However, there are a lot of people who are eligible to retire and they are accessing their retirement maybe before they would normally do that. Mm-hmm. So we can expect to continue to see some sluggish processing times, which I know is a bummer because they're already a little slow.
Right. One of the advantages of the O-1 is you can get premium processing of your case if you pay the additional fee. So and because it is a temporary visa, the process is not as long as a green card application. So it is a good stepping stone if you're looking to ultimately move permanently to the U.S. While you wait for a green card process, do the O-1. Typically, we will recommend doing the O-1 first and then pursuing a potential green card because the O-1 by itself is not recognized as what's called dual intent per se, although a lot of times they won't question that, but we won't get into that. That's for another video, I think. So usually pursue the O-1 first and then look at the opportunities for a green card. And yeah, I mean, staffing levels is something that the Trump administration has seen across the federal government to make cuts. USCIS, we haven't seen a huge impact, at least yet. So like always, our advice is don't wait. Waiting to apply for any kind of visa or green card application is usually not a good idea because demand continues to grow and delays may get longer. Any other significant changes that you have seen under Trump? I mean, what I have seen has been the push in certain fields. Let's not confuse O-1 with the EB-1A or an EB-2 NIW. Those are green card applications. But the O-1 sometimes can have, you can have clients that sort of may fit into the EB-1A or the EB-2 NIW and are doing the O-1 for temporary reasons. Have you seen any significant changes in what officers may want to see regarding particular fields We see oil and gas being a big one that the Trump administration is pushing. What about continuing to attract STEM or tech workers to the U.S.?
So I haven't seen any huge changes in the adjudication patterns. STEM is always going to be something that remains a strong category. Entrepreneurs is another category that continues to remain strong. And oil and gas, of course, because of that reprioritization by the government. But even people who are in fields that are maybe considered ones that are a little bit targeted by this administration, such as environmental sciences or certain kinds of social causes, I haven't seen big changes in the adjudication patterns, even for those fields. So I feel good about continuing to represent a diverse clientele in all the types of work that they're doing, but certainly it's something that we're going to keep an eye on.
And that's an important point. If you can maybe share with us as a former USCIS officer, obviously you went through probably different administrations. You were there for 13 years. So did that affect you? Who was the president of the United States? Did that in any way affect your adjudication standards?
No. So that's a really great question, though. So there are things that change every time there's a change in the political administration. One thing that changes is who heads the agency. And every time there's a change in agency head, there's changes in kind of your daily existence, right? So those things can be annoying, but they don't typically affect the core of your decision making. And that remained true. So even under the Trump administration, even though there were some pretty stressful things that happened.
During the first Trump administration.
The first Trump administration, correct. There were some pretty stressful things. And some of them had to do with the president and some of them didn't. You know, I mean, the COVID pandemic, things like that. And the agency's response to it. You know, so there were some things there that really made my job different, but not the core of the decisions that I was making. So, for example, we always had a robust telework system. And during the COVID pandemic, everything switched from telework as a privilege and you do it some to it was happening every day. And they were, you know, the file situation, pick up and drop off of physical files was different. So there were things like that didn't have anything to do with who the president was. It was just those change in the social conditions that really changed that work for me. But the guidance on how we adjudicated the cases did not change. And that was really comforting in many, many ways. So sometimes you'll see different types of work get prioritized at the service centers. Usually, though, it's based on the timeliness of the filings and or the presence of premium processing. Mm-hmm. So since the election, we've seen a real bloom in premium processing. And so that's all officers are working right now. Those upgrades and the new files that were filed with premium, that's all anyone is doing. And there is a backlog. And of course, in I-140s, we've seen some broken clocks, which means that they're not able to get the case adjudicated in the time that they're given to do that. So those kinds of priorities will change, but the guidance didn't change. And one interesting thing about the Trump administration, they could have revoked that Biden guidance on STEM adjudications, and they didn't.
Haven't. They haven't.
Right.
That's important. That is important because a lot of folks were, right after the elections, were already saying, oh, we think Trump is just going to get rid of all of that. Mm-hmm. And they haven't done that. I mean, they have canceled or revoked hundreds, thousands of Biden actions. Executive actions and regs and et cetera. They have not touched the STEM guidance. So that's a positive. Let's hope that remains that way. But picking up on one point that you mentioned that I think it's important is the fact that the Trump administration, at least to date, this new second administration, but even under the first administration, they were very positive with the high rates of approvals for O-1s, over 90% or higher, and that continues to be the case as far as we've seen. So approval rates are very high for O-1s, but also they have made it very clear that they want to try to attract people based on merit. I mean, not only for immigration purposes, but even at the federal agency levels, they don't want to implement what they call DEI. They want people to earn, whether it's their green card, I guess, or their visa or their job based on merit. And the O-1A is one of the ultimate merit visas that you can obtain for having extraordinary abilities in your field. So you would continue to hope that this administration will prioritize, because like you said, they clearly will not prioritize asylum, refugee, humanitarian, which we're not going to get into that today. That may not be a policy that is a good idea down the road, but that's what they have taken as at least priority from an immigration perspective. So if they're not going to prioritize those types of applications, the merit-based visas should see more priority.
We would hope. We would hope.
Let's hope that 2025 continues to be sort of the merit year for immigration. That is what we specialize here at Colombo and Hurd. Let's also hope that immigration continues to be that hope for a lot of folks around the world that are looking for making the American dream come true. We here at Colombo and Hurd represent clients from all over the world in merit-based petitions, high-skilled immigration, Mandy being one of our expert attorneys, former USCIS officer. Mandy, is always a pleasure to share these news, and we'll do more videos like this. If you like these types of videos with Mandy and I, you can click the like button before you can subscribe to our channel so you can keep up to date with news. Mandy, thank you again.
Thank you.